everyone. Welcome to Crime in Court. This is another episode of the Canton Cover Up Commonwealth versus Karen Reed Trial 2.0, and we are going to be going over the latest filing from the defense regarding James Crosby. So, who is James Crosby? You can see on the thumbnail we are reconsidering Crosby, and he is pictured on the thumbnail there. And he is the expert that the Commonwealth is putting forth as the dog. He's a dog trainer, he's a dog behavioralist. He deals with aggressive canines. He has his own consulting in dealing with aggressive canines. He's been doing this for many, many years. Before that, he's a retired cop. So he has that kind of cop background, just FYI. But his background does not include medical, veterinary, forensic, odontology, none of the things that he is required to be an expert in order to opine on the things that the Commonwealth wants him to testify to. So, the defense has already requested to to exclude his testimony, and if not, they wanted a Daubert hearing. The judge, Canoni, just recently ordered that he will be allowed to testify as to the medical causation of injuries on John O'Keefe's, Officer John O'Keefe's arm, and he's basically going to opine and say that they were not dog bites, but that's again, he's not an expert. So because Judge Bev decided, without giving the defense a lot Daubert Lanigan hearing, which is the least she should have done before she just allowed him to testify, they are asking her to reconsider. So let's read through this together and see what you guys have to think about this. All right, so this is the defendant's motion for reconsideration of the March 6th order denying defendant's motion to exclude the testimony of the Commonwealth's witness James W. Crosby, MS, PhD. Now comes the defendant, Karen Reed, and respectfully requests that this court reconsider its March 6, 2025 court order denying the defendant's motion to exclude the testimony of the Commonwealth's witness James W. Crosby, MS, PhD, or Dr. Crosby. And after such reconsideration, defendant requests that the court exclude the entirety of the proffered testimony of Dr. Crosby. In the alternative, and at a minimum, defendant requests an evidentiary hearing to determine whether the Commonwealth can meet its burden to satisfy the requirements of Daubert Lanigan as regards to Dr. Crosby. The defense could complete its questioning of Dr. Crosby in approximately 1/2 day of any hearing. So they need about 4 hours. They got a half a day of questioning that they want to put this Dr. Crosby through because they don't believe that he is an expert. Nor did he use methodology that is recognized in the field of forensic odontology or medical identification of wounds, things like that. He didn't use normal methodologies that are accepted in those fields. So the court's March 6th order, in denying defendant's motion to exclude the proffered testimony of Dr. Crosby, the court stated in its March 6th order that the Commonwealth has satisfied the foundational requirements of Daubert Lanigan. The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. Actually, Judge, no, he's not. But those are Judge Bev's words. And there is an appropriate basis for his opinion in the record, and the proposed testimony, principles, and methods are reliable. So she just made the finding that his principles are reliable, even though she didn't even allow a Daubert hearing to determine that. The defendant's objection goes to the weight of the evidence, not its admissibility. She's also the one that claimed that only medical doctors could opine to medical causation or forensic uh, examiners to could only opine to the medical injuries, the medical causation of injuries in her court. That is her words, and then she just totally ruled against herself. She just makes herself look like a fool, is all I think of when she does stupid shit like this. Sorry. All right, so the court did not provide any record, citation, or other record evidence for how the Commonwealth had met its burden to satisfy the five foundational requirements, including prominently the methods are reliable requirement. So, how did she determine that? Is what just like I said, like, how did she just come up on her own and say that was they're reliable without even having the ability for the defense to ask questions about it, about what methods they used. Nor did the court address the alternative request of the defendant that a Daubert hearing Lanigan be held should the court not exclude Dr. Crosby outright on the papers alone. So they requested, in the alternative of excluding him, give us a Daubert Lanigan hearing because we need to determine his methods. The March 6th order contrasts with the court ordered 2-day evidentiary hearing of Dr. Marie Russell. Like, let's just be clear about the um, hypocritical way or the two-sided justice, because Dr. Marie Russell for the defense had to come in for a 2-day evidentiary hearing, and Dr. Crosby doesn't even have to at all. Why? How? Like, what is your line of reasoning, Judge Bev? That makes absolutely no sense. You said medical doctors could, and yet you made her jump through all these hoops. And now Dr. Crosby, yeah, sure, go right ahead. Talk about the fact that those injuries are not dog bites because you deal with aggressive dogs. That has nothing, like, that doesn't even compute. Okay. So March 6th order contrasts with the court-ordered 2-day evidentiary hearing of Dr. Russell, a medical doctor with approximately 30 years of experience as an emergency medical physician and forensic pathologist. Dr. Russell co-authored peer-reviewed books on dog-inflicted wounds on humans and submitted an 11-page report before the hearing in which she documented her pattern recognition methodology with robust citations to peer-reviewed studies and articles that appeared in 27 footnotes throughout her report. The instant motion for consideration. The defendant does not waive any and reserves all of the basis for exclusion of Dr. Crosby as stated in her original exclusion motion. Yet, for efficiency, in this reconsideration motion, the defendant focuses on just factor 4 set forth in Polk, namely, that the theory underlying the opinion is reliable. This factor is also known in the Daubert-Lanigan parlance as the methodology prong. A failure of any one of the 5 foundational factors, so you have to meet all 5, not just 4 out of, you have to meet all 5. A failure of any one of the 5 foundational factors as set forth in Polk compels exclusion of the proffered testimony at issue. The Commonwealth opposition to the defendant's exclusion motion. The Commonwealth had 4 opportunities to show that it can meet the Daubert-Lanigan methodology prong. Its written opposition dated February 17, 2025, the supplemental report of Dr. Crosby dated February 19, 2025, in which he discusses the mold aspect of his unsupported mold measurement methodology, but failed to account for the absence of any requisite overlay in his methodology. Oral argument on the exclusion motion on March 4th, 2025, and the list of cases in which Dr. Crosby has testified in court which was submitted to the court on March 6th, 2025. So those are all the ways in which he could have cleared up his methodology and reliability um, of his methodology. So in each of the opportunities, the Commonwealth failed to even attempt. They failed to attempt to show that the purported mold measurement methodology employed by Dr. Crosby in opining on whether the molds to the right arm of the decedent were caused by a dog bite or dog attack is generally accepted in the relevant medical or scientific community, or that his methodology meets the apt Daubert-Lanigan factors. So there was no kind of the methodology that he used. He took this mold, the way that he did it, and all the things. There was no relevant or scientific studies that he was actually basing his methodology on. So he can't back it up, is basically what that means. All right, so notably, Dr. Crosby has never attempted to make such a showing either. His report is completely bereft of even a mention of satisfaction of general acceptance of his mold measurement methodology or satisfaction of the Daubert-Lanigan factors, let alone a showing of meeting them, as he has never submitted an affidavit to support anything about himself, including his qualifications or documentation of any kind of how his purported methodology is generally accepted and otherwise reliable with citations to medical or scientific literature. So, if normally an expert would provide all of this, they would provide their qualifications, an affidavit, affirming these are my qualifications, this is the methodology that I used, this is why this methodology is used in the field. They're supposed to back that up. And none of that was in his report. So he's had the opportunity and has failed multiple times to clear that up. The February 17th, 2025 affidavit submitted by Mr. Brennan is likewise of no weight in the inquiry, as he lacks first-hand knowledge or the requisite expertise of the subject matter of the dispute. So Mr. Brennan submitted his own affidavit about Dr. Crosby, but that, like, if you're gonna go to those lengths, just let Dr. Crosby do the affidavit. Like, get it worked out with him that he does the affidavit and not Mr. Brennan, and then you can have his expertise and knowledge and methodology all included, but he didn't, and there's a reason for that, in my opinion, because this guy's a quack. But even in his affidavit, Mr. Brennan mentions nothing about satisfaction of the common acceptance precept or the Daubert-Lanigan factors. Tellingly, Mr. Brennan merely states in paragraph 7 in a bald conclusion that Dr. Crosby has engaged in substantial methodology. Well, what is that substantial methodology, though? Substantial does not begin to satisfy the requirement that the mold measurement methodology of Dr. Crosby is supported by evidence of common acceptance in the relevant medical or scientific community or satisfaction of the relevant Daubert-Lanigan factors. Likewise, in its written opposition, the Commonwealth stated that Dr. Crosby engaged in recognized methodology to study the abrasions. Again, what is that recognized methodology? But wholly failed to state any source for such recognition. So it's a recognized methodology, but we're not going to tell you who recognizes it. Commonwealth's opposition at 2. There is none, they say. There is none. No recognition. No methodology that is recognized, they should say. All right, so as a result, the Commonwealth has provided the court with no basis on which to conclude that the mold measurement methodology of Dr. Crosby is reliable, the prerequisite for satisfying the fourth factor of Polk, the methodology prong of Daubert-Lanigan. The court cannot satisfy its gatekeeper function by invoking the same conclusory statements as the Commonwealth has invoked here regarding a reliable methodology. There's a little shade at Judge Bev. Like, you, Judge Bev, can't just say, well, the Commonwealth said it's reliable, so therefore it's reliable. That's not how it works. You're supposed to let the proceedings work themselves out. So that's not, yeah, it's not up to Judge Bev necessarily. I mean, it is ultimately, but she shouldn't just be not looking at both sides. All right, the gatekeeping function of the court under Rule 702 and its importance. Case law makes clear that the gatekeeping function and the trial court is especially significant. This is all the more so in light of the seriousness of the charges lodged at the Commonwealth here. As the Massachusetts Guide to Evidence states, Massachusetts Rule 702 is based on Federal Rules of Evidence, Section 702, which additionally maintaining while additionally maintaining the common acceptance test. Sorry. All right. So whatever the common acceptance test is. So as a result, federal decisions interpreting the Federal Rules of Evidence 702 are particularly instructive. The gatekeeping function of the trial judge under Daubert Lanigan. So here is what Judge Bev's role is in a Daubert Lanigan. It's so the gatekeeping function precepts is of paramount importance. Under Daubert Lanigan, the motion judge, in her role as gatekeeper, has significant function to carry out in deciding on the admissibility of a scientific expert's opinion. The reason for this importance was recently underscored as follows: because Rule 702 grants experts wide latitude to offer opinions, including those that are not based on firsthand knowledge or observation. Expert evidence can be both powerful and quite otherwise satisfy the apt Daubert Lanigan factors, yet it has failed to do so each time. This failure is not an oversight of or mere happenstance. Rather, it is because the methodology of Dr. Crosby is not generally accepted in the relevant medical or scientific community and cannot satisfy the Daubert Lanigan factors. Conclusion: under Daubert Lanigan and Commonwealth versus Polk, respectfully, the court is duty bound to fully exercise its important gatekeeper function by examining the record and making what can only be one finding: the failure of a reliable methodology by and thus the exclusion of Crosby on the papers alone. So we think it doesn't even meet the standard, or it doesn't even meet the qualification or the minimum for a Daubert Lanigan. He should just be denied on the papers alone because of the lack of methodology. Any testimony by Dr. Crosby at trial about his unsupported mold measurement methodology would seriously mislead the jury into believing that his methodology is based in science and is reliable. So it would not only would it not help the jury, it would mislead the jury purposefully. Or maybe not it purposefully, but it would definitely mislead the jury because it is, well, putting them on without knowing that it's not scientifically reliable. Yeah, that's pretty much misleading them on purpose. And nothing could be further from the truth. And because the issue of how the injuries to the arm of the decedent is a key issue for both parties, his testimony with the sponsoring imprimatur of the Commonwealth would be extremely prejudicial to the decedent. In the alternative, and at a minimum, an evidentiary hearing of Dr. Crosby is compelled. So if you can't exclude him on the papers, we compel you to, at the very minimum, have a Daubert Lanigan hearing. And here is Robert Alessi's affidavit in support of his motion that we just read. Says, I, Robert J. Alessi, hereby state as follows. I am a partner with the law firm at DLA Piper LLP, and I am a member in good standing of the Bar of the State of New York. I am co-counsel for Ms. Reed and have been admitted pro hoc vice in the above captioned matter. I make the following statements based upon my personal knowledge and support of the defendant's motion for reconsideration, denying defendant's motion to exclude the testimony of the Commonwealth witness, James Crosby. All right, so in denying the defendant's motion to exclude the testimony of Dr. Crosby, the court stated in its March 6th order that the Commonwealth has satisfied the foundational requirements of Robert Lanigan. The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. There is an appropriate basis for his opinion in the record, and the proposed testimony, principles, and methods are reliable. The defendant's objection goes to the weight of the evidence, not its admissibility, because the Commonwealth has not shown and cannot show that the mold measurement methodology of Dr. Crosby is generally accepted in the relevant medical or scientific community and cannot satisfy the 5 foundational factors identified in Commonwealth versus Polk or the Daubert-Lanigan factors, and for the other reasons discussed in the accompanying motion for consideration of the March 6th order denying defendant's motion to exclude the testimony of the Commonwealth's witness. Defendant respectfully requests that the court reconsider its March 6th order and exclude the testimony of Dr. Crosby. In the alternative, the defendant requests that the court convene a Daubert-Lanigan evidentiary hearing on Dr. Crosby. Defendant reserves all and does not waive any arguments or rights about the other failures of the Commonwealth to meet its burden of proof regarding Dr. Crosby, such as the lack of the requisite qualifications of Dr. Crosby, signed under the pains and penalties of perjury this 12th day of March 2025. So there you have it. That is the latest filing from the Karen Reed defense team. They are trying to be, I think, a little bit more proactive in some of their motions here. And with this, making her reconsider things, I love it because you're putting a little more pressure to Bev's uh, feet, and I like it. A little more fire to her underneath her, because she needs it. She's totally gone rogue and she's doing her own thing and she's not following the law. And so she needs these attorneys to help kind of remind her, hey, judge, you made the wrong decision here and you should probably reconsider this. She won't. She probably won't, but who knows? And she really should give them the Daubert-Lanigan hearing. And if not, I don't know. I mean, there's so many appealable things, but again, like you have to wait until she's convicted to appeal. There's not a whole lot of like emergency appeals that you can do right now. So it's just very frustrating to sit by and watch it all. And I mean, it's got to be frustrating for poor Karen and her family having to just keep getting hope up and then shot down and hope up and shot down because it seems like every time we have something good, the Commonwealth wants to come and combat it with something bad. And it's been going like this for years and I can't take it anymore. Like this has to stop. It's got to stop now because they need to stop persecuting an innocent woman. I don't know. I mean, what's going on in our society where the good guys aren't the good guys anymore? It's very it says a lot and it's happening or not happening. I should take that back. It's the light is being shown on these areas more so now than ever. And it's great. And we need the awareness and we need the transparency, but it's disheartening knowing that this is going on everywhere and that Karen Reed could be any one of us. And the way that John's memory and his the preservation of his memory and the way that his investigation was done, if that was you or a loved one of yours, you wouldn't want that. And they need to start taking accountability. And it's about time we start getting some, like, I don't know, the DOJ needs to start entering the courthouses and maybe listening in on Judge Bev. Although that's been a rumor that that the feds have been in court hearings. I don't know if that's true or not, but um, that would be something if the feds were sitting in on the proceedings, trying to see what was going on with how Bev and Hank were conducting themselves. That would be something, huh? I don't know. I wouldn't hold my breath for it, but that would be really cool if that happened. And at some point during the trial, they just were like, you know what? Arrests have been made. Judge Bev going to federal court. That would be great. That would be great. That's my dream. Judge Bev, Hank, all the law enforcement officers, Michael Proctor, all of them, handcuffs. That's what we need. That is definitely what we need. Let me know what you guys think in the comments below. Is Judge Bev going to allow a Daubert Lanigan hearing for Dr. Crosby? Or is she going to stick to her guns and allow him to testify? Let me know in the comments below, and I will see you guys in the next one. Take care. Bye now.